The appeal of Mark Ed Williams and 2 others against the Kuwait Enforcement Authorities and no.
Yes, Mr. Chaplain.
My Lords, my Lady, I appear together with my learned friends Mr Pullinger and Mr Shaw for the appellants in this matter. My learned friends Mr Allison, King's Counsel, Mr McCourt Fritz, King's Counsel, and Miss Reynolds, King's Counsel, appear for the respondents. My Lord, this appeal gives rise to a single overarching issue, which is of considerable importance to the Cayman investment market and potentially also of wider significance beyond that. That issue is in what circumstances a limited partner in a Cayman Islands exempted limited partnership may be permitted to bring a derivative claim for and on behalf of that partnership. The Court of Appeal of the Cayman Islands in this case held that the plaintiff limited partners here should be permitted to bring their derivative claims because the general partner was subject to an inhibition when it came to considering whether or not to bring those claims. That inhibition was identified by the Court of Appeal as a potential conflict of interest that meant that when considered from the perspective of the plaintiffs themselves, the plaintiffs could have no confidence that the decision of the general partner not to bring the claims was an independent and fair one. In concluding as it did, the Court of Appeal established and applied in our submission the wrong test, setting the bar which a limited partner must overcome before being permitted to bring a derivative claim far too low. In doing so, we say with respect that the Court of Appeal misconstrued and misapplied the statutory test under Section 33 of the Exempted Limited Partnership Act, the ELPA, failing to give sufficient weight to the overall statutory context. We submit that the Court of Appeal adopted a threshold test, as the respondents accept, that sets the bar lower for bringing a derivative claim in the case of a Cayman Islands exempted limited partnership than in any other context in which derivative claims arise, including what we say are closely analogous contexts, be it companies, trusts, or English limited partnerships.
You said that they failed to give weight to the statutory context, so you'll be taking us to other provisions that are relevant.
I will presently, my Lord, yes.
Thank you.
We also say, by way of introduction, that the Court of Appeal's approach gives rise to undesirable and potentially damaging uncertainty for ELPs, general partners and limited partner investors. But we say, in short, that properly construed and applied, the requirements of Section 33 are not met here, such that leave to bring and continue the derivative claim ought not to have been given. Now, my Lord, with that introduction in mind, I was going to invite attention to the Exempted Limited Partnership Act, which appears in our bundles at page 2397. And we say that it is important to understand the structure of the statute and the nature of the exempted limited partnership for which it provides. But by way of context, as of the most recent figures, there are something in excess of 36,000 registered ELPs in Cayman, and they might be regarded as very much being the vehicle of choice for investment funds in that jurisdiction. They are effectively a form of passive investment structure, as we'll see, which enable limited partners to invest in a fund, the partnership, but then to take no part in its management, which is instead provided to the general partner. So, my Lords, just drawing attention to one or two of the statutory provisions, can we begin, please, at Section 3, which is on page 2399, which provides a saving for the rules of equity and common law applicable to partnerships, as modified by the Cayman Partnership Act, to apply to exempted limited partnerships, except where they are inconsistent with the express provisions of this Act. So a saving for the rules of equity and common law, save where they are specifically ousted by the terms of the statute. And then moving on to Section 4. Section 4(2) provides for general partners, and one will see from there that they, the general partners, are to be liable for all the debts and obligations of the partnership in the event that the assets of the exempted limited partnership are inadequate, whereas the limited partners shall not be liable for the debts or obligations of the exempted limited partnership, save for particular circumstances provided for in Section 20 and Section 34 of the Act. So the general partner has the liability, and the limited partners have limited liability, effectively limited to the amounts of their contributions. That position is then reflected and entrenched by other provisions of the Act. So turning next, if we may please, to Section 14 on page 2405. This is, in our submission, an important provision. Section 14, subsection 1, firstly provides that a limited partner shall not take part in the conduct of the business of an exempted limited partnership in its capacity as a limited partner. And then subsection 2 provides that all letters, contracts and so forth shall be entered into by or on behalf of the general partner on behalf of the exempted limited partnership. And I'll come presently to draw some of these threads together by way of submission, but that we say is an important provision. As too, on the same page, is Section 16, which provides for the assets of the exempted limited partnership, including all shows in action, to be held on the terms of a statutory trust by the general partner. And then over the page, please, at 2406, at the bottom of the page is Section 19, which addresses duties of the partners. And we'll see from Section 19, subsection 1, that the general partner is subject to an express statutory duty to act at all times in good faith and subject to any express provisions of the partnership agreement to the contrary in the interests of the exempted limited partnership. Whereas by contrast, subsection 2, subject to any express provisions of the partnership agreement to the contrary, a limited partner of an exempted limited partnership in that capacity does not owe any fiduciary duty in exercising any of its rights or authorities or otherwise in performing any of its obligations under the partnership agreement to the exempted limited partnership or any other partner. So the general partner owes a statutory fiduciary duty to the partnership itself. The limited partners, by reason of Section 19, subsection 2, owe no duties either to each other or to the partnership. And then perhaps finally, for the time being, in terms of the statutory provisions, Section 33, with which this appeal is of course primarily concerned, is at page 2416. And that provides, subsection 1, that legal proceedings by or against an exempted limited partnership may be instituted by or against any one or more of the general partners only, and a limited partner shall not be a party to or named in the proceedings. And the sole statutory exception to that is provided by subsection 3, which provides that a limited partner may bring an action on behalf of an exempted limited partnership, so a derivative action, if any one or more of the general partners with authority to do so have, without cause, failed or refused to institute proceedings. Now, my lords, my lady, having identified those 6 statutory provisions, can I identify what we say in our submission are, I think, 9 important characteristics of an exempt limited partnership for present purposes. The first is, perhaps self-evident, that an ELP is a creature of statute. That said, as we've seen, unless modified by the Act, the rules of common law and or equity are otherwise expressly preserved by Section 3. The second point to note is that although not covered expressly by the terms of the statute, an ELP does not have a separate legal personality distinct from its partners. And there, the position is, of course, similar to a general partnership and by way of contrast to a company. The third point we would...
So you would accept that an ELP, like a partnership in the Cayman Partnership Act, is the relation that subsists between persons carrying on a business with a view to profit?
My Lord, yes.
Yeah.
Yes. The third point of the 9 that we draw attention to is that the partners of an ELP may be either a general partner or a limited partner or both. Here the latter does not arise. We're only concerned with a general partner on the one hand and a limited partner or limited partners on the other. The fourth characteristic we identify is that an important characteristic of an ELP and a point of distinction from a general partnership is that the limited partners in an ELP have limited liability. That was sections 4, 2 and section 20. The fifth characteristic is that in our submission, the quid pro quo of limited liability is that a limited partner is prohibited from taking part in the conduct of the partnership business. And that's provided for by section 14(1). Sixthly, but relatedly, instead the business of the ELP is carried on exclusively by the general partner, which enters into all contracts on behalf of the partnership. Section 14, subsection 2. Seventhly, it is the general partner that holds all assets, including shows in action, on trust for and on behalf of the limited partnership. That was section 16. And eighthly, as regards the duties of partners, by section 19, the GP is subject to an express statutory duty, requiring the general partner to act in the interests of the partnership, whereas by contrast, unless the partnership agreement provides to the contrary, a limited partner owes no fiduciary duty either to the partnership or to its other partners. And ninthly, and of course most importantly for the purposes of this appeal, the statute provides that proceedings by and against an ELP are to be addressed in accordance with section 33. Now, as regards section 33, at this stage, in our submission, we simply draw attention to the fact that, consistent with first principles, the Act provides that a claim belonging to a limited partnership and held on trust for the partnership by the general partner must be brought by the general partner. Exceptionally, and again we say consistent with first principles, the statute also permits a derivative claim to be brought by a limited partner for and on behalf of the partnership where the general partner has refused or failed to bring that claim without cause. Now, before turning to the meaning of without cause and the Court of Appeal's reliance on the law relating to derivative claims in other contexts, it might be helpful, I hope, just to spend a few minutes looking at the limited partnership agreement in this case, the terms of which in our submission reflect the statutory scheme. That appears beginning, I think, at page 1651. Where we see the amended and restated limited partnership agreement, which is the agreement currently in force. And I draw brief attention to page 1658 and clause 3 of the limited partnership agreement, which sets out the rights and duties of the general partner. And in particular, I draw attention to clause 3.1a, which provides, consistent with the Act, that the operation of the partnership shall be vested exclusively in the general partner. One sees the balance of that clause.
Is there anything in the agreement which departs from the default rules in the Act
My Lord,
that is relevant to our consideration?
my Lord, no, but by way of perhaps emphasis, the terms of the partnership agreement are entirely consistent with the statutory scheme and include in particular, if one looks at 3.1b, Roman 3, it is the general partner that has the right and power to employ or consult such persons as it shall deem advisable and so forth. And then perhaps of particular relevance, at Roman 6, it is the general partner that has the right and power to sue, prosecute, settle or compromise all claims against third parties and so forth.
Yeah.
So the contractual scheme mirrors the statutory scheme, and these limited partners contractually agreed that it was to be the general partner that was going to be the relevant decision maker when it came to bringing claims against third parties. And perhaps we need not turn it up, but limited liability of the limited partners is set out in terms at clause 5.1a at page 1669. Now, before leaving this agreement, there is perhaps one other clause to which I should draw attention at page 1676, and that's clause 8.5, which deals with the withdrawal or removal of the general partner. And perhaps I can just pause to allow my lords, my ladies, just to read that provision. Now, the effect in summary of that provision is that if the general partner, for example, has liquidators appointed over it, or seeks to withdraw by resigning as general partner, then that will constitute a dissolution event, causing the partnership to be dissolved and its affairs to be wound up, unless all limited partners agree in writing to the continuation of the partnership business. Now, without wishing to leap too far ahead in the analysis or my submissions, we would suggest that the effects of that, if the Court of Appeal is right, and if it is right that a general partner, once conflicted, is always conflicted, so that it can't purge any conflict by the appointment of new independent directors, then the only way to avoid a derivative claim being brought which the general partner determines is against the interests of the partnership is for the general partner to withdraw, or perhaps, based on the Court of Appeal's indication at paragraph 163 of its judgment, to have liquidators appointed. In either event, thereby causing the dissolution of the partnership. And we do submit that it is relevant to consider the potential chilling effect of that if the Court of Appeal is correct. A limited partner holding a minority interest, perhaps even a tiny one, less than 1%, can assert a claim against a third-party service provider providing services to the partnership, as we would say is the case here in the case of the fourth appellant, on spurious grounds that the service provider does not appear to have provided valuable services to the partnership. The limited partner, relying on the Court of Appeal's decision, argues that the general partner cannot determine whether or not to bring that claim because it is conflicted. Because as we've seen, it is inevitably the general partner who would have appointed the third-party service provider. And on the claim, it is the general partner that has failed to ensure that valuable services have been provided to the partnership. What then in those circumstances is the general partner to do? Permit the derivative claim which it regards as not being in the best interests of the partnership, because, for example, as has happened here, it might give rise to a counterclaim for the underpayment of fees or some other liabilities, or withdraw, causing the automatic dissolution of the partnership, which the other limited partners will be powerless to prevent if the rogue minority interest limited partner does not consent to the continuation of the partnership. Now, my lords and my lady, in those circumstances, on that hypothesis, the rogue minority limited partner thereby holds the partnership, the general partner, and its other limited partners to ransom. And it does so by intermeddling in the partnership business, which is the very thing it is barred by statute and by the terms of the limited partnership agreement from doing. Yet, my lords, my lady, that is the effect we submit of the Court of Appeal's decision. And that alone suggests, we would say strongly suggests, that the decision is wrong. Now, having identified those particular features of an ELP under the Act and how they are reflected in the terms of the partnership agreement here, may I move next to some submissions on the construction of Section 33.
Just before you go there, to be clear, Clause 8.5 may well be a common provision in written agreements, but it's not a default rule of the Act.
My lord, that's correct.
Yeah.
Now, the Court of Appeal found that in applying Section 33, or in construing and applying Section 33, and the without cause test for which it provides, it may assist for a court to identify whether there are special circumstances which might justify a derivative claim in other contexts. That's paragraphs 95 to 96 of the Court of Appeal's judgment. And in our submission, where the Court of Appeal essentially went wrong, was failing to pay sufficient regard to what is required before special circumstances can be found to exist. By way of introduction to special circumstances and other contexts, in our submission, in every context where a derivative claim is permitted, what in essence is required are special circumstances to justify the exceptional course of a derivative claim being brought so as to avoid injustice. And the particular injustice here is that a potentially meritorious claim will not be brought, but instead be stymied by the relevant decision maker. The reason the claim will not be brought is usually either because, one, wrongdoer control, that is, that the alleged wrongdoer is in control of the entity that is taking the decision whether or not to bring the claim, and in which the claim is vested. Or secondly, a conflict of interest on the part of the relevant decision maker, which means that the decision maker will not bring the claim. And examples that appear in the authorities are, for example, where directors have benefited from the wrongdoing themselves, but are not themselves the wrongdoers. And in the trust context, the conflict between the power and duty of a trustee.
So you don't challenge, do you, any of the points made by the Court of Appeal in paragraph 140?
My lord, no. In essence, we don't challenge the test, namely that the statute provides a freestanding test that falls to be applied, as the Court of Appeal said. In construing and applying Section 33 in the statutory test, regard can and here should be had to the law relating to special circumstances.
You just say they didn't interpret that law correctly.
or interpret or apply it correctly. And there are a number of aspects to where they went wrong, both in terms of setting the threshold for special circumstances to be established too low, and relatedly focusing, when it comes to looking at an inhibition on the relevant decision maker, either at the wrong decision maker, the general partner level, to the exclusion of its directors, or without paying sufficient regard to the position of the directors of the general partner. And it's those two errors, really, that fundamentally led the Court of Appeal into error.
But that's all application of the test. You're not quarrelling with the Court of Appeal's approach to construction.
My lady, no. And equally, for completeness, we don't challenge or take issue with the Court of Appeal's determination as to when the test falls to be applied,
Yeah.
or the threshold for applying that test. So, in looking at derivative claims in other contexts, I was going to move next to the company context. And here, of course, the company context at common law in Cayman, which follows the English common law as it was before the 2006 Act. And one starts with the proposition that in the case of a company, the management of the company is given to the directors and not to the shareholders, just as here in the case of the ELP, the management of the ELP is given to the general partner and not the limited partners. And it follows, and is of course well established, that absent exceptional circumstances, a claim belonging to the company must be brought by the company acting through its directors. And again, the position we say is analogous to the present. The partnership claim belonging to the partnership must, pursuant to the statute, be brought on behalf of the partnership by the general partner. And that of course, is the rule in Foss and Harbottle, to which there are only a few limited exceptions. The only one potentially engaged here is the so-called fraud on the minority. And that exception is engaged where the company's own constitution, which ordinarily provides for commercial decisions to be taken by the board, cannot be operated properly because of a fraud on the minority. That is, what is required is that the majority are implicated in the relevant wrongdoing or have benefited personally from it. So in our submission, the relevant requirement is for there to be a connection between the relevant wrongdoing and the inhibition on the majority of the directors to discharge their duties to the company when it comes to considering whether or not the company should bring the claim. Now, although one talks about the exception to the rule in Foss and Harbottle, the position is most often analysed by reference to the decision of the English Court of Appeal in Prudential and Newman, which appears at page 2841 of the bundle. And I was going to invite my lords and my ladies' attention to just certain of the passages in the judgment of the Court of Appeal, acknowledging that while often referenced and applied, much of what is said about derivative actions in this lengthy judgment given ex tempore is strictly speaking obiter. But nonetheless, it's often been cited as effectively the source of the modern learning on derivative claims in a company context. And one sees at, first of all, page 2847 between letters D and F, the identification of the general rule from Foss and Harbottle. And then over the page at 2848, at letter A to B, point 5, the exception, the so-called fraud on the minority, is identified. Next, I think I should draw attention to page 2856, just below letter D to just after letter F, where the Court of Appeal identified what it meant by controlled. And you'll see, my lords and my lady, that controlled is put in inverted commas. And the Court of Appeal sets out there that control embraces a broad spectrum, extending from an overall absolute majority of votes at one end to a majority of votes at the other end, made up of those likely to be cast by the delinquent himself, plus those voting with him as a result of influence or apathy. And then moving on to 3 lines below letter F, and what one sees that the Court of Appeal identifies a dilemma and how that dilemma is to be resolved in terms of assessing whether wrongdoers are in control of the company so as to permit the derivative claim to be brought.
Seems quite a leap to say that just because this is another kind of derivative action, the Cayman legislature intended to incorporate into its law the complicated jurisprudence of Foss and Harbottle.
Well, my lord, that's obviously an issue with which the parties and the courts below have had to grapple with. What did the legislature intend by adopting the without cause test? And in the absence of any other guidance, given the similarities in position, to which I'll come, but I've identified some already, between both the company law context and, as we'll come on to see, also the trust context, given that the general partner holds the assets of the partnership on the statutory trust. It was our submission, which was effectively accepted, as we've seen by the Court of Appeal, that recourse could be had to the principles developed in these other contexts when construing Section 33.
I can understand the reference to the trust context, but I mean, there are 2 rules in Foss and Harbottle. One is the proper plaintiff rule, and the other is the vindication of an action by simple majority. And we're not in that context here at all. What we have here is a perhaps unique statutory provision creating a derivative action when the general partner acts without cause.
My lord, that is, of course, with respect, absolutely correct, albeit, given that one is grappling with the statutory test without any other real guidance as to how it falls to be applied,
yes,
the guidance that has been developed in the jurisprudence in these other contexts and our submission, and as we say, rightly found by the Court of Appeal, is of assistance, if in nothing else.
What other than the proper plaintiff rule can you take from Foss and Harbottle?
Well, from Foss and Harbottle, it's the proper plaintiff rule coupled with the fact that the emphasis that it provides as to the derivative claim being an exception to the proper plaintiff rule. And
I don't think that's in dispute.
no, and flowing from that, consistent with the trust context as well, and as we'll see, the English limited partnership context, that the threshold test in these other contexts is normally set at a relatively high level.
It's a special circumstances level in the context of trusts, which is perhaps a closer analogy.
It is, to which I'll turn.
It's not even really, it's more than an analogy, because property, including rights of action, are held on trust. So the general partner is a trustee.
My lord, yes.
Whereas the relevance of company law could at best be a matter of analogy. And the analogy isn't a very close one because of the separate personality of the company and the consequent restrictions on the powers of shareholders that we see in Foss and Harbottle.
My lord, I agree, and I don't seek to press the company context beyond that level of analogy as so to speak, build part of the picture as to how exceptional a derivative claim is and how there is a consistent approach adopted in the jurisprudence in these different contexts which set the bar, as the respondents accept, at a higher level than set by the Court of Appeal in this case for a Cayman Islands exempt limited partnership.
Well, derivative claims aren't necessarily such a rarity in the context of trusts.
My Lord, they may not be such a rarity, but nevertheless, when one looks at the special circumstances that have to be established, in our submission, the threshold test is set higher than the Court of Appeal found in this case. And perhaps it may be of more assistance if I move from the company context to the trust context.
Well, it seems to me that you can go straight to the trust context, as Lord Reid says, because you've got Section 3 of the ELPA, you've got Section 58 of the Cayman Partnership Act, both of which preserve the rules of equity.
My Lord, yes.
And then you've got a statutory trust.
At Section 16.
Yes.
Yes.
Precisely.
So, looking then at special circumstances, perhaps a convenient starting point is the passage to which we've made reference in Lewin at paragraph 47-008, which is at page 3183. And this is a passage, as we identify in our written case, that has been cited with approval in many of the other cases, including in the limited partnership case of Henderson, to which I'll turn presently, albeit in an earlier edition of the work. And one sees here the special circumstances test and some examples of what would constitute special circumstances.
So you accept that a conflict between interest and duty is an example?
My Lord, yes.
Of circumstance.
My Lord, yes. And I also accept, as reflected here and coming from Roberts and Gill, that special circumstances are not confined to these examples. The categories of special circumstances are not closed. But I do emphasise the next sentence, the guiding principle is that there must be exceptional circumstances which embrace a failure excusable or inexcusable by the trustees in the performance of a duty to the beneficiaries to protect the trust estate or to protect the interest of the beneficiaries in the trust estate.
Yes, well, I mean, that's fairly close to the words without cause, isn't it? A failure to perform a trust duty without cause.
My Lord, yes. Yeah. And where we say the Court of Appeal went wrong was in diluting that test to something less than a failure to discharge the trustee's duty. And I'll come on to...
Did they? Did they dilute that test or did they apply it?
Well, they purported to apply it, but in its application, in our submission, they in fact diluted it. I'm not sure whether it would be helpful to take my lords and my lady to Roberts and Gill, given the position is summarised in that passage from Lewin, although the relevant passages are at Lord Collins at paragraphs 45 to 46 and Lord Walker at paragraph 110.
Could you give us the electronic bundle page numbers at least?
I can, forgive me. It's page 2890 for Lord Collins and 2908 for Lord Walker.
Thank you.
And the sentence to which I was addressing my last submission in the passage in Lewin, referring to a failure excusable or inexcusable by the trustees in the performance of the duty owed by the trustees to the beneficiary to protect the trust, comes from Cayman Citibank, which is at page 2752 of the electronic bundle. Now, before leaving trusts and moving to partnerships,
Could you give me the page number again, please?
I'm so sorry, my Lord. 2752 at letter F.
Thank you.
And before leaving trust, although of course I have to return to this when coming to the application of special circumstances in this case, can I identify perhaps three significant features of the special circumstances test? The first is that, as we've seen, ordinarily at least, the special circumstance will relate to an inhibition on the claim being brought by the trustee who has the power and right to do so. The second feature is that where the trust is not a bare trust, a refusal by the trustee to sue will not without more itself count as a special circumstance justifying a derivative action being brought by the beneficiary. And thirdly, and relatedly, a mere difference in opinion will not suffice. But what is required ordinarily is a failure on the part of the trustee in the performance of their duties to the trust. Equivalent, we would say, without wishing to stretch the analogy, to directors failing to discharge their duties to the company in the company law context. Now, that then I think brings me to the English limited partnership case of Henderson, a decision of Mr. Justice Cook, which appears in the electronic bundle at page 2656. We've also now provided, with apologies for it being somewhat late, the Queen's Bench report of this decision in an additional bundle, but it may be convenient to stay with the main electronic bundle if that's what everyone is working from for the time being. This case concerned a limited partnership under the Limited Partnership Act 1907. And the limited partners in this case sought to bring derivative claims against both the general partner and the investment manager appointed by the general partner with respect to alleged mismanagement of the fund. The relevant provisions of the English Act are set out at paragraph 13 of the judgment, page 2659 of the electronic bundle. From which it will be seen that the relevant provisions insofar as there being a limited partner and a general partner, the general partner having control of the management of the partnership and the limited partner being subject to a statutory prohibition in taking part in the management of the partnership business, are all very similar to the equivalent provisions in the Cayman Act, to which I took my Lord and my Lady earlier this morning. What is missing from the English Act is an equivalent of section 33. But the learned judge notes at paragraph 14, page 2660, that in what he says is the ordinary way, the limited partners cannot sue a third party in the name of the partnership. Only the general partner can do that. So with that in mind, the learned judge then turns at paragraph 17 at page 2662 to the derivative claims and the effect of pursuing them.
What he says is that, by reference to section 6, if a limited partner were to interfere in that way in the management, then he would lose his limited liability.
And indeed, he so finds that in permitting the derivative claim against the investment manager, but not the general partner, the quid pro quo for bringing the derivative claim would be the loss of limited liability.
Yes. So it really shows we're a very different territory from company law.
Well, save, as we'll see at page 2662, my lord, when turning to the derivative claims and the effect of pursuing them, the learned judge starts with company law before then moving to special circumstances and trusts. And I fully accept that the analogy only takes one so far, but
Well, it tells you what the normal rule is, who is the proper plaintiff, which is 33 subsection 1.
my lord, yes, yes.
You know, I mean, I suspect this is a... Well, I'm not sure if the judge was right to treat the classic example as being the case of a minority shareholder. I mean, the situation we're dealing with, the closer analogy might be Victorian cases to do with beneficiaries being concerned about the administration of the trust.
And in fairness to the judge, he having addressed the company law context, does then turn to Roberts and Gill and the position in trust at paragraph 19 of the judgment at page 2663.
Yes, just before that, I mean, you'd found on the second sentence and following in paragraph 18, I imagine that, you know, that derivative actions arise where justice of the case demands it, and there's a reference there to trust. But it has to be a special circumstance.
Yes, and he then, having identified there has to be a special circumstance to justify the exceptional course of permitting a derivative claim, he then turns to special circumstances and Roberts and Gill.
Yes.
And again, perhaps by way of emphasis at Roman 4 there, the learned judge relies in particular on the point made by Lord Walker in Roberts, that while the category of special circumstances has never been defined, it is not closed, and that in the non-company situation there's no need to obtain the prior permission of the court to bring a derivative action. Again, same position under the ELPA here. The claimant has to plead the special circumstances which entitles him to the court's indulgence. Those special circumstances are part of the action. And then at paragraph 20...
Part of the cause of the act.
Part of the cause of action, yes.
Which may be relevant to the cross-appeal.
My lord, yes. And then one sees at paragraph 20 reference to the equivalent passage in the earlier edition of Lewin, to which I've already made reference. Now, in that case, the special circumstances of conflict of interest that were relied upon are identified in paragraphs 21 and 22. So the conflict of interest was that the general partner was a sister company of the investment manager, and the general partner could not, in practice, be expected to sue itself or the sister company, the manager. And the judge then found that there was no need or room for a derivative claim against the general partner because the limited partner had their own cause of action against the general partner. That's paragraph 28.
It is perhaps important that the last sentence of 21, that the partnership agreement itself gave rise to the conflict of interest as an inescapable fact to which all the limited partners had agreed.
My Lord, yes, it had in that case. It had in that case. And notwithstanding that, leave to bring that derivative claim was granted. As we'll see from paragraph 34, first of all, at page 2667, and then ultimately at paragraphs 48 to 54, and I think paragraphs 48 to 54 really pick up on the point that my Lord Reid makes to me, and that the general partner was saying that part of the contractual bargain to which the limited partners agreed was the inherent conflict of interest, and they should be held to that. But the judge concluded at paragraph 54 that while those points carried considerable weight, they did not conclude the issue, but reinforced the need for special circumstances before a derivative claim can be made. And then one sees, as one does there at the end of paragraph 54, if there is in truth no realistic way in which the limited partners can obtain redress against the manager, such an action may be required in order to avoid injustice. And he then develops that point at the end of paragraph 55, where he finds, as the claimants submit, an irremediable conflict of interest between the general partner and the manager, and the fact that this is built into the architecture of the partnership, both by contract and statute, is in the end nothing to the point. And then he reaches his conclusions over the page at paragraphs 59 and 60. So ultimately, the judge found that special circumstances did exist. He identifies the contractual position under the partnership agreement. He identifies the difficulties and uncertainties in removing the general partner, and ultimately concludes that the irreconcilable conflict of interest on the part of the general partner in this limited partnership is what constitutes the special circumstance which would require the derivative claim to be pursued. Now, if I can attempt to draw together a summary of the relevant principles so far from these other contexts. Firstly, in whatever context it arises, a derivative claim is exceptional, and it represents an exception to the general rule that a claim must be brought by the party in whom the right of action vests, be that the company, the trustee, a partnership, or in the case of a limited partnership, the general partner. Secondly, as we've seen, particularly in the trusts and the English limited partnership context, a derivative claim may only be brought where justice requires it and where special circumstances are established to justify it. Third, while the class of special circumstances is not closed, ordinarily the special circumstances will relate to an inhibition that prevents the claim from being advanced by the entity with the right to bring it.
Could you repeat that one?
My Lord, yes. While the class of special circumstances is not closed, ordinarily the special circumstances will relate to an inhibition that prevents the claim from being advanced by the entity with the right to bring it. Fourthly, ordinarily, that inhibition will be an inhibition relating to control. That is, an inhibition to which the relevant decision makers are subject. So the inhibition will relate to a failure of the relevant decision maker to discharge their duties, in the case of the trustees to the trust, or the directors to the company, or the general partner to the partnership. And the decision makers will not be discharging their duties either because they are themselves alleged to be the wrongdoer or related to them, or because they've benefited from the wrongdoing, or because they are subject to an actual and irremediable conflict of interest. Fifthly and relatedly, a mere refusal to bring a claim will not suffice. Something more beyond a refusal to bring the claim is required. Now, in our submission...
It's obvious from the legislation.
My Lord, yes, and those are the principles we seek to draw from the other context, and we then say, moving to the legislation, that consistent with the position outside the legislation, a mere refusal or failure on the part of a general partner to bring a claim will not justify the derivative claim being brought. Something more is required, and that something is provided by the statute to be a failure or a refusal without cause. And we, with respect, agree with the Court of Appeal that that connotates without good cause. And we also agree that in construing and applying the without cause wording, the court should have regard to the established principles relating to refusals or failures to bring claims in the other context which I've been addressing, and in particular, trusts.
You say the inhibition must prevent the claim from being advanced. Where do you get that from?
My Lord, that comes from, in the trust context, the example of the conflict between the power and duty of the trustee. That the trustee is in, as we've seen in the example of the statutory trustee in the limited partner case of Henderson, is irremediably conflicted. And therefore, the claim is effectively being stymied, which is the wording that's been used in the company context, because the decision maker cannot be expected to bring the claim. And it cannot be expected to bring the claim for a variety of the reasons that we've identified by way of example. One would be the conflict, another would be that the decision maker is under wrongdoer control. But in each context, whether it's trusts, English limited partnerships, or indeed for that matter companies, the relevant inhibition bears on the decision maker's ability to make an impartial, conflict-free decision as to whether or not to bring the claim, and effectively leads to the conclusion that the claim will be stymied because of the inhibition.
Yes, I mean, I think you put forward the statement in Lewin on trusts at 48008, which is 3183, as an accurate statement. And that certainly isn't confined to there being an inhibition. I mean, it says that the guiding principle is there must be exceptional circumstances which embrace a failure excusable or inexcusable by the trustees in performance of a duty to the beneficiaries to protect the trust's estate, etc. So without cause really means, does it not, a failure to perform their duty, rather than a disagreement as to the merits of a claim?
My Lord, yes, and it's the reason why there's the failure to bring the duty is really where the inhibition comes in.
Yeah, well, but that is just an example of a failure to perform the duty. There may be other, a trustee may not be inhibited, but may make a very serious misjudgment, might it not?
My Lord, that's certainly true, and it's one of the reasons why the categories of special circumstance is not closed, and why we've accepted in our submissions, as we did in our submissions before the Court of Appeal, that, for example, a completely irrational unreasoned decision would be a breach of duty, but may not be the product of any inhibition.
Yes, but it may not be confined to irrationality. A decision may be without cause, without it necessarily being irrational.
My Lord, I would accept that as well.
Okay.
So, my Lords, with those principles identified, can I move to some submissions as to the relevant decision maker here, and first of all look at the matter from a position of principle before looking at the position on the facts. The special circumstance found to exist by the Court of Appeal in this case was a potential conflict of interest on the part of the general partner. The Court of Appeal thought that the relevant decision maker was the general partner, but with respect, its reasoning in this respect was both confusing and contradictory. And my Lords, my Lady, I make that submission because the Court of Appeal, in upholding the judge's decision that the relevant decision maker was the general partner and only the general partner, nevertheless seemed to accept that the appointment of independent directors did or could make a difference, albeit they thought not enough of a one in the final analysis, and also that the appointment of a liquidator perhaps would make a difference to the position of conflict. And we see that at both paragraphs 159 of the judgment, that's page 98 of the electronic bundle, paragraph 159, first of all, having identified the allegations being made in the proceedings, the Court of Appeal say that on the face of it, by reason of the obvious and serious conflict of interest, D1, that's the general partner, is under an inhibition which would amount to special circumstances in the context of a trust or limited partnership. And this inhibition also means that the failure by D1 to bring proceedings against D2 to 4 is without cause for the purposes of section 33(3). But having identified that that was the position...
You say that's a potential conflict of interest, do you?
Well, I do because of what comes next. Because what the Court of Appeal do, my Lord, is they say, first of all, that on the face of it, the general partner is subject to this obvious and serious conflict of interest. Then at paragraph 160, the Court of Appeal identify the defendant's arguments as to why that is not the position. And they identify the first argument is that the present directors of the general partner, namely the independent directors as we've called them, the FFP directors, are wholly independent, not in office at the time of the alleged wrongdoing on the part of the general partner, and they do not therefore suffer from any conflict of interest.
That's your argument, it's not the Appeals finding.
My lady, yes, that's our argument that's being identified as to why they say it's different. And the second argument that they identify that we were advancing at paragraph 162 was that the independence of the directors was fortified by an undertaking that Mr. Williams had given that the shareholder of the general partner will not exercise any powers so as to remove the directors or interfere in any way in the exercise of their functions. So having identified the position on the face of it, conflict, the Court of Appeal then identified the two arguments which we relied on as saying that the position was different and had been changed. And then at paragraph 163, the Court of Appeal expressed their conclusions. And their conclusion was that those two submissions did not overcome the inhibition referred to earlier. And they first of all, as I've indicated earlier, upheld the judge and found that he was right to focus on the entity which is the general partner rather than the directors for the time being of that entity. And then a little way through that paragraph, one has the point about the liquidator. So the Court of Appeal says new directors are not...
We get onto that. They say that the general partner is subject to conflicts of interest, and that's actual conflict, isn't it?
That is actual conflict, which is the on the face of it position that they've identified. And then one gets this slightly odd wording as to, in that sentence, that the general partner cannot be seen to be in a position to take a fair and independent decision about the potential litigation.
Well, it's the consequence of the actual conflict.
Well, it's a consequence of the actual conflict, but feeds into the point that comes next. New directors are not in the same position as a liquidator who is appointed by and subject to the supervision of the court, and therefore clearly is and is seen to be independent of the company, its directors and shareholders. So, pausing there, what the Court of Appeal seemed to be contemplating was that if instead of appointing new directors, instead a liquidator had been appointed.
Liquidator to whom?
The liquidator of the general partner.
General partner.
Then that would have made a difference, because the liquidator clearly is and is seen to be independent of the company, its directors and shareholders.
But I wonder where that takes you anyway, because the liquidator of the general partner would owe a duty to the creditors, not of the ELP, but of the entity that was the general partner. So he may be independent, but his duty would be to maximise the returns for the creditors of the general partner.
Well, that's why, among other reasons, we say, my Lord, that the Court of Appeal's reasoning here is, with respect, slightly difficult to follow.
I mean, if you liquidated the whole ELP, then clearly you would have an independent person looking after the interests of the ELP. But why should the liquidator of the general partner seek out claims which against third parties, which might result in those parties suing the general partner under the equivalent of Part 20?
Well, only for the same reason that independent directors might do so, namely recognising the statutory fiduciary duty that the general partner owes to the partnership, which would not be discharged if there were good claims against third parties in which the general partner then failed or refused to bring. But one of the difficulties we submit with the Court of Appeal's approach is that the Court of Appeal was correct to identify that the natural persons making the decision are relevant to the consideration of whether special circumstances exist or not, but fell into error in disregarding the existence, appointment and status of the independent directors to the general partner in this case. That they identify that the natural person decision makers at least could be relevant by making this point as they do about a liquidator.
Well, it may have, as the discussion illustrates, they may have been mistaken in what they said about a liquidator.
Well, my Lord, I think with respect, we agree, albeit for different reasons, because we say that the liquidator here, essentially for the reasons as this discussion has demonstrated, is in no different or better position than new directors when it comes to...
Well, it's in a different position, because the liquidator's duty is owed to the creditors of the general partner, whereas the director's duty is to the shareholders of the general partner.
Save that in both cases, the statutory fiduciary duty owed to the partnership is still one which the general partner, under whoever's control, must comply with, which we say, of course, is of significance. But having identified that...
But the liquidator would no longer be carrying on the business of the general partner. He would merely be winding it up and trying to maximise the return to the creditors. But anyway, you say it's a bad analogy, and I'm suggesting it's a bad analogy, perhaps for different reasons.
My Lord, yes. What perhaps is more pertinent for the submission I'm seeking to develop at this stage is that the Court of Appeal was right to identify that the natural person decision makers within the general partner are to be considered and are of relevance when considering if special circumstances arise. And
well, I wonder if they were right about that.
Well,
I mean, if the problem is a conflict of between the duty as directors of a general partner and the to act in the best interests of the general partner, and the general partner's duty to act in the best interests of the limited partnership as a whole, that conflict isn't going to be resolved by simply changing who's sitting in the director's seat.
Well, there is the difficulty that we've seen as to if the Court of Appeal's analysis where it begins on this point is right. The general partner, once conflicted, remains always conflicted. Then one has this, we would submit, incredibly unattractive position where the only way that the conflict can be addressed and resolved is through, leave on one side the potential appointment of liquidators, the removal of the general partner, with everything else that then entails. And in our submission, that can't be the effect of a proper construction and application of the statutory test, because it would effectively permit partnerships to be hamstrung when these types of issues arose and potentially held to ransom. Of course, as my lords and my lady will know, subsequent to the Court of Appeal decision, receivers have been appointed to the general partner for the specific purpose of having conduct of the various pieces of litigation. And so they may well be in a different category even to a liquidator appointed over the general partner itself. The important point where we say, with respect to the Court of Appeal got it right, is that the natural persons making the decision must be relevant to a consideration of whether special circumstances exist. And having recognised that, the Court of Appeal conclude at the end of this paragraph...
Not if the special circumstance isn't one that depends on the identity of the individuals. All you're doing is changing who's sitting in the boardroom. If the nature of the problem is such that it's not going to be resolved by changing the identities of those individuals, then it's irrelevant.
Well, my Lord, I think, with respect, I wouldn't disagree with that proposition. If the identity of the individuals will not make a difference to the underlying problem, then perhaps not. Equally, viewed the other way, it might be thought that simply replacing the general partner that remains under the control of the wrongdoers does not remove the special circumstances. Yet on a strict logical application of the Court of Appeal's reasoning, that would work. Because if you're just looking at who the general partner is and not those in control of it and those making the decision, the wrongdoer, in principle at least, could simply appoint a new general partner or cause a new general partner to be appointed. The new general partner is free of the conflict because you only look at the general partner level, and the problem is removed. Whereas, of course...
You're envisaging the wrongdoer appointing a general partner. Well, I could see that could give rise a new general partner. That would hardly remove the conflict. But let us assume that the clauses that you found on in your contract here don't exist in an ELP. Let us say an ELP is simply working under the default rules. There would be no requirement, would there, if the parties agreed to change a general partner and to continue, there'd be no requirement for a dissolution or a winding up. The partners could agree to do that.
Not as a matter of the application of the Act, no, my Lord, that's right.
Not as a matter.
No, that's right. The particular position here as regards dissolution comes from the particular terms of the limited partnership agreement. But the point I was seeking to make about the replacement of the general partner is, if in principle the Court of Appeal is right to focus only on the general partner, then by way of logical extension, if the wrongdoer were in a position to replace the general partner with a new general partner, the conflict at the general partner level, if one was only looking at the general partner level, would be removed, notwithstanding that the two general partners are under the same wrongdoer control. So we say, by testing it that way, one can see that the Court of Appeal was plainly correct to this extent, to say, well, one at least has to pay regard as to who the natural person decision makers making the relevant decision are. And what they conclude at paragraph 163, having identified a submission to which I've already made reference, that the directors owe a fiduciary duty to act in the best interests of the general partner, and the submission that because the general partner owes fiduciary duties to act in the best interests of the partnership, that the directors therefore have a duty to act in the best interests of the partnership. And the Court of Appeal concluded, however, there is certainly the potential for conflict between acting in the best interests of the partnership, which might include taking action against the first defendant as a co-conspirator, and acting in the best interests of the general partner, which might be said to include the avoidance of being sued. Now, here again, the Court of Appeal with respect go wrong in that they have already decided that there's no room for the general partner effectively to sue itself because the limited partners have their own direct personal claims in conspiracy. But what they are admitting in their analysis, we say partially correctly, is that it is relevant when considering if the special circumstances exist to consider who the natural persons making the decision in question are. And they find that the appointment of the independent directors makes a difference, but an insufficient difference, because, as per the last sentence, there is certainly the potential for conflict that still arises.
If the general partner sues the co-conspirators in the name of the ELP, the general partner is exposing itself to the co-conspirators saying, well, if you're right, it's not just us who are the wrongdoers, you are too. You are to contribute to the sums that might be due to the ELP. So by saying, well, the limited partners have an action against the general partner, that doesn't get rid of the problem. The problem is that the co-conspirators could bring in the general partner as a third party into the action.
Well, my lord, they might, but nonetheless, obviously, that doesn't detract from the point that the general partner in pursuing the third party co-conspirators is seeking to discharge its fiduciary duty and make a recovery on behalf of the partnership.
But there's a conflict between performing its fiduciary duty and exposing itself to the defendant's claims.
There is, but my lord,
it's not a potential conflict. There is an actual conflict.
That situation is not that uncommon. For example, to go back to the case of a liquidator appointed to a company, just for a moment. A liquidator is appointed to the company, and the liquidator determines that the former directors are miscreants and should be pursued, together with those who assisted them. So for example, the liquidator discovers that there are misstatements in the company's financial statements, giving rise to claims against both the former directors and the auditors. Now, to a certain extent, just as here, in bringing that claim against the former directors and the auditors, the liquidators will be impugning the prior conduct of the company itself, and indeed exposing the company to potential claims from the third parties. But there's no question in those cases of the liquidator being somehow inhibited by that potential, or indeed actual conflict of interest, from deciding whether or not to bring the claims. So too, if instead of liquidators being appointed, new directors are appointed to a company that discover prior wrongdoing by the directors that they have replaced, together with third parties. So too, perhaps even in the case of a trustee, perhaps all the more so, the case of a corporate trustee, where new directors are appointed to the corporate trustee that uncover wrongdoing by their predecessors. In those circumstances, we would respectfully suggest there's no inhibition caused by the conflict of interest that by bringing the claim against the third party may itself give rise to claims by the third parties against, as the case may be, the corporate trustee itself, relating to its historic conduct while under the control of the miscreants. In all of those circumstances, there is no substantive difficulty when it comes to the new appointees, be they new directors of the corporate trustee, new directors to the board of the company, or a liquidator to the company, taking an independent decision as to whether the claims against the third parties should be pursued. So we say with respect, the Court of Appeal was right to recognise and acknowledge, as they did, that the natural persons who are the decision makers in question are relevant to the question of whether special circumstances arise or not. And they were right, in particular, to identify that the appointment of the new directors in this case could at least make a difference, and they seem to have suggested at paragraph 163 did in fact make some difference, albeit not enough of a difference, so as to remove the special circumstances. And I should, for completeness, perhaps draw attention to paragraph 167 as well, at page 100, which flows from the findings at paragraph 163. Because there the Court of Appeal finds that the undertaking given by Mr Williams is insufficient to overcome the inhibition from which the defendant as general partner suffers. So again, pausing there, they at least contemplate and acknowledge that it is, at least in theory, possible that the inhibition can be overcome. They then say that if one stands back and considers how it would appear to the plaintiffs, given the allegations that they make, for the decision as to whether to seek recompense from any one or more of D1 to 4 to be left in the hands of D1, they would have no confidence that a fair and independent decision has been taken, even following the appointment of the FFP directors. In our judgment, they would be justified in this lack of confidence. And they then say there is no doubt in our view that D1 was and is suffering from an inhibition, which leads to the conclusion that, subject to the exercise of any discretion, it is appropriate for the plaintiffs to bring derivative claims on behalf of the partnership. So, again, as we saw in paragraph 163, the Court of Appeal appear to be recognising that the inhibition is something that could be addressed, albeit it was not sufficiently addressed here, and then seem to have focused not so much as on the presence of an actual conflict of interest, but on how matters would appear to the plaintiff limited partners themselves and the confidence that they would have that a fair and independent decision had in fact been taken. By contrast, what the Court of Appeal does not find is that the decision by the independent directors in this case not to bring the claims was in fact infected by the conflict of interest, such that it fell to be impugned or vitiated. And my lords, we say, unsurprisingly perhaps, that the Court of Appeal was absolutely right in not making such a finding.
Infected in what way?
Infected by, for example, the directors consciously preferring the interests of the general partner over those of the partnership, or by the actual conflict of interest.
If there is a conflict of interest, the decision is infected by that conflict, whatever the decision is, isn't it?
And didn't the judge find that the provision of information and the decision about what information to provide led to that conflict?
Well, the difficulty with that, my lady, and I appreciate the Malone Friends rely heavily on the findings made by the judge and the Court of Appeal's indication that, although they did not have to consider the position, had they felt the need to, they would have found that those were findings that he was entitled to make.
Yes.
The fundamental difficulty with the findings made by the judge was that the Court of Appeal found correctly that he had applied the wrong test. And so he had only found that there was a real prospect, for the purposes of the strikeout test, of the plaintiffs being able to demonstrate that the individual independent directors were subject to a conflict of interest. He did not find, to the higher standard that the Court of Appeal found to be the one that fell to be applied, of a good arguable case or strong arguable case, that was in fact the case. So you have the position where the judge's findings really are of, with respect, no value because he applied the wrong test to too low a threshold. The Court of Appeal then makes no findings of its own when applying its test as regards the individual directors as the natural person decision makers. But rightly, we say, acknowledge that the status of those individuals is of relevance when considering if special circumstances arise. Now, we've provided the references in our written case, but the three particular points upon which we rely here, of course, as regards the independent directors, is that they are financially disinterested and unconnected with the alleged wrongdoing, as set out in their evidence and is really not in dispute. I'll just give the references given the time. It's Mr. Lewis's third affidavit at paragraphs 18 to 26, page 1264, and Mr. Lewis's fifth affidavit at paragraph 29 at page 1543. So firstly, they are clearly independent. Secondly, and perhaps unusually, they had undertaken really very extensive investigations into the derivative claims with the benefit of two firms of Cayman attorneys and leading counsel, and had concluded, or rather pausing there, they had undertaken extensive investigations, and they are set out in summary at Lewis 3, paragraphs 62 to 64, page 1280 of the electronic bundle, and also paragraphs 402 to 405, page 1382, together with Mr. Lewis's fifth affidavit, paragraph 151.
What page number was the 402 to 405?
1382, my lord.
1382, thank you.
And in those paragraphs, Mr. Lewis also identifies that as well as looking at the substance of the claims in terms of their merits, he and Mr. Child had also undertaken a commercial assessment of whether it was in the interests of the fund to bring the claims, having regard to the potential for counterclaims, which of course is exactly what's happened. The fund itself now faces a very substantial counterclaim from my clients as a result of having brought the derivative claims, a cross-claim, forgive me. And sorry, I was...
Presumably the court's entitled to take a view about strength of the claims. I think the Court of Appeals said that. So if they thought there was no merit in the claim, that could be a reason for not giving permission to pursue it.
My lord, that's right. That's right.
Was that an argument that was addressed to the court in this case, or was it accepted that the claims were sufficiently arguable?
It was accepted that they were sufficiently arguable because there had been no application to strike them out or have them summarily dismissed. So the position was effectively neutral on the findings made by the Court of Appeal, because on the one hand, they could not say that they were so bad that it would not be just and no special circumstances arose to permit the derivative claim to be brought. Equally, they did not, as part of their reasoning as we see, find that they were of such merit that weighed in the balance when considering if special circumstances existed, and if so, in the exercise of their discretion, whether the claims ought to be brought. So the position was effectively neutral. And forgive me, I was giving one more reference, which was to Mr. Lewis's fifth affidavit, paragraph 151, at page 1571. So those set out the investigations and the various considerations that the directors had in mind, including advice on their fiduciary duties. Having then undertaken those investigations, the directors concluded that the derivative claim should not be brought because to do so would not be in the best interests of the partnerships. But they nevertheless did intimate claims against third parties where their investigations indicated that there were claims which would be in the best interests of the fund to pursue. And again, perhaps I can just give the reference to that. It's Mr. Lewis in his third affidavit again, at paragraph 73 to 81. That's page 1287, in relation to fees paid to Apache. And in the same affidavit, paragraphs 295 to 298, at page 1350, in relation to fees paid to KGLI, KSCC. Now, in circumstances where we have the position, as I've sought to describe it, on the basis of the judge's findings about the independent directors, where the Court of Appeal, having identified that their appointment in principle could make a difference, but finding that if it did make a difference, it only reduced the actual conflict to the potential conflict, but making no findings themselves about the independent directors, one's left with the position as I've just sought to describe it, where these two gentlemen have been appointed to the board and are in control of the general partner. They are independent. They have undertaken, with the benefit of appropriate legal advice, extensive investigations, and concluded, subject to the two exceptions that I've identified, that the derivative claims ought not to be pursued. In those circumstances, our submission is that that was a paradigm case of where the general partner had decided not to pursue the claims with cause. And going back to perhaps where we began this morning and the statutory scheme, in those circumstances, for the Court of Appeal to permit the limited partners who are prohibited by statute, and as it happens by contract under the LPA, from meddling or participating in the management of the business of the fund, to bring the derivative claims against the will of the general partner acting through its new independent directors, we submit does violence to and fails to apply the statutory scheme and the statutory test under section 33. And without wishing to go back and points that I think I've already made in the course of attempting to address the questions that have been put to me, where the Court of Appeal effectively went wrong was in failing to pay sufficient regard to that statutory scheme. But in particular, looking at these last paragraphs that we have in their judgment, it was in failing to give sufficient weight and consideration to the appointment and status of the independent directors when considering whether or not special circumstances existed. And we say the error there first was to the extent that it relied on looking, as the judge did, at the general partner so as to exclude the position of the relevant natural person decision makers from the consideration, and that was wrong in principle. To the extent that they did not completely make that error in principle because they acknowledged that the individual decision makers were of relevance, then they failed to pay due regard to the position of the independent directors and the investigations and decisions that they had made. But bearing in mind again, it is only in exceptional circumstances that the court will interfere with the decision made by the relevant decision maker, hence the requirement for special circumstances to exist. And perhaps less importantly, but for completeness, to the extent that the decision relies on dismissing the value of Mr. Williams' undertaking, then that too was an error. First, because the undertaking was not, in fact, even necessary for the independent directors to have that status as being independent. Second, it nevertheless does provide additional comfort as to the position of those directors. And third, to the extent that the Court of Appeal's decision relied on the Court of Appeal of Bermuda's decision in the St John's Trust Company case, then again, the Court of Appeal with respect fell into error. In the Bermudian case, the alleged fraudster was seeking the reappointment of his corporate vehicle as trustee of the trust. And the undertaking in that case did not meet the concern as to the alleged fraudster's continuing ability to influence the trustee going forwards. Here, the relevant decisions by the independent directors not to bring the claims have been taken, and there is no suggestion or finding that that decision was influenced by Mr. Williams. On the contrary, the directors have confirmed that they have acted independently.
I'm just wondering if you can reassure me on a point which isn't an issue in the appeal, I don't think, but it's just been troubling me slightly. At the stage of the proceedings before the Court of Appeal, I mean, these are, what we're dealing with here, I think, are summonses to strike out claims brought against the defendants, the various defendants. And the summonses seek to have the claims struck out on the basis that the claims are being brought by the ELP, which is okay as far as it goes, but they're being brought on a derivative basis by the limited partners. Now, at the stage of the proceedings before the Court of Appeal, the general partner was of course, a party to the appeal. Now it's not. If a defendant is sued by an entity which has a claim against it, is it proper for that defendant to take a point about the proceedings being against it being of a derivative, being brought in a derivative capacity?
My Lord, yes. Perhaps begin by way of footnote, which may be not as helpful, but originally, of course, the partnership was not named as a party. It was added by amendment, I think, after the decision of Justice Parker. But ultimately, to answer the point more directly, I hope, the question is one of standing, because as we've seen from what I hope has been demonstrated to be the most analogous context of trusts, the limited partner only has standing to bring the claim in the name of and on behalf of the partnership on a derivative basis if it can satisfy the test under Section 33. And if
so even though the general partner takes no objection now to the proceedings being brought on a derivative basis, it's still open to defendants to take a point, because it goes to the standing of whom? I mean, not of the claimant, but of the entities who are in reality standing behind the claimant.
My Lord, yes, although it's in a similar way in my submission to where the beneficiaries under a trust only have a cause of action if they can satisfy the test for bringing a derivative claim and have to name the trustees as defendant. Here, in a similar way, the plaintiffs have no standing to bring or pursue the claims, including in the name of the partnership, unless they satisfy the statutory test under Section 33.
Well, that's very helpful. It does occur to me that if it goes to standing, then that's a matter that perhaps has a bearing on the cross-appeal also. But we'll come to that.
We'll come to that in due course. It may be that it's more convenient for me to deal with that in my reply, yes. Having heard what my learned friend has to say. I was just reminding myself, if I could, briefly, as to, I think I did not misspeak, but those with me will correct me, I'm sure, in indicating that the partnership was added as the third plaintiff.
Well, that would be normal practice, wouldn't it?
Yes, and had not been followed. But I think that was by way of re-amendment in green. We can check the position. But it may have been after the Court of Appeal rather than beforehand. But there's certainly the third plaintiff as matters currently stand. My Lord, just give me a moment, given the time. My Lords, may, unless there's anything I can particularly assist further with at this stage, I perhaps should leave myself some additional time in reply to deal with the cross-appeal.
Yes.
Could I just confirm one thing? Is it a matter of agreement that the limited partners, if they proceed with this action, will have exposed themselves to unlimited liability in the event of the insolvency of the ELP?
That would be our contention. I don't think it's accepted.
It's
But I
not
will be
accepted.
corrected.
I see. But perhaps it will be explained why not. Be better.
Thank you. Thank you very much. Yes, Mr. Allison.
My Lords, my Lady, we'll commence by responding to Mr. Chapman before moving to the cross appeal. First, noting that Mr. Chapman helpfully accepted that paragraph 140 of the Court of Appeal accurately sets out the section 33(3) test, and also, in response to my lady's question, expressly said that he accepted the threshold within that test imposed by the Court of Appeal. Now, we'll say that's important in due course when it comes to discretion, because of course that includes an acceptance that the test for the court is essentially an evaluative one based on the material before the court at the time. Subject to the court, we propose to break our submissions into 7 parts. First, a few points in relation to the background from particular paragraphs in the judgments. Second, some observations regarding the nature of ELPs and why, if an analogy exists, it is to English limited partnerships and trusts and not to companies. Third, to explain why we say the Court of Appeal was right to say that the test focuses on the general partner when determining whether a derivative claim should be brought, and not, as contended by the appellants, to focus on the individual directors of the general partner from time to time. Fourth, to explain why the appellants are wrong to try and superimpose lock, stock and barrel principles from other spheres. Fifth, to explain why the findings of the lower courts mean that this appeal is futile, even if the appellants manage to persuade the court that the statutory test focuses on the directors from time to time rather than the general partner as a legal entity. And 6, to deal with the attack on the Court of Appeal's discretion. I think that really boils down to a submission that they failed to pay proper weight to the FFP directors' views. And then finally, the question of timing raised by the cross appeal. So if that structure commends itself to the court, I will start with the key factual matters, which I hope I can deal with relatively briefly. The first matter is a high-level summary of the claims. I may, if the board is content, just give a note to where the Court of Appeal gives the headline claims. That's paragraph 152, Roman 4 to Roman 8 of its judgment, and that's at page 96 of the record. And in particular, the court will see their claims for dishonest assistance in breaches of trust, knowing receipt of trust property, breach of trust by the general partner, breach of fiduciary duty, and a conspiracy involving the general partner, the second defendant, the third defendant. So that's the nature of the claims. Now, a point of detail in relation to that claim, which has always been common ground, but my Lord Legate asked Mr. Chapman about this morning. What about the merits of the claim? Is it common ground that the claims are seriously arguable, and must that be assumed for the purposes of today? The answer is yes. That has always been the case, and there has been no attempt to strike the claims out on the merits. The only challenge made by the defendants to the claims is on the ground that the gateway under section 33(3) is not met. And I think that will feed in later to my Lord Reid's question about is there something unusual now the general partner isn't here and the defendant seeking to rely on this as a reason for the claims not going ahead.
Do they have reverse summary judgment procedure in Cayman?
They do, and strikeout, yes. The second background matter concerns the attitude of the limited partners as a whole to the claim. And could I turn that up at page 95 of the record in the Court of Appeal's judgment? The board will see paragraph 152 sets out the position of the limited partners, and the following points can be noted. The plaintiffs account for 65% of the economic interest invested in the exempt limited partnership. They are bringing the claims. Moreover, it's not just the plaintiffs bringing claims based on the serious allegations of wrongdoing. Two other limited partners are bringing similar claims. That's subparagraph 2. They are limited partners who invested just over 15% of the funds in the port fund. Now, as the Court of Appeal record, that means that we have over 80% by value of the limited partners bringing claims based on these allegations. What about the balance? 14% are associated with the general partner, and the rump of around 5% have not expressed a view one way or the other. Now, in relation to the remaining 19%, including indeed those connected with the defendants, the board will note that not one limited partner has sought to appear to oppose the pursuit of the derivative claim. The third background matter is the genesis to the claims, and that's that the plaintiffs have been raising very serious concerns with the general partner concerning its management of the port fund over a lengthy period of time. Now, those complaints go back to 2016, before the commencement of the proceedings. And to give the board a reference for that, it's in the statement of facts, but it's also in the record at page 19, within the judgment of Mr. Justice Parker. Paragraph 34 at the bottom of page 19. Under the heading Background to the Plaintiff's Complaints. It's recorded there that the complaints have been raised concerning the management for many years, going back to 2016. And then what happened next was, as recorded there, the plaintiffs sought large amounts of information regarding the financial condition and state of business of the port fund. Those requests were resisted, which led to proceedings under Section 22 of the Exempt Limited Partnership Law. Now, we can show the board that if it would help. Essentially, it's a right for the limited partners to request information on the financial condition of the fund. Those proceedings were resisted. Importantly, as recorded within the Court of Appeal's judgment, those proceedings were resisted by the FFP directors after their appointment. And can I just make that point good by taking the board to page 97 of the record? Paragraph 154, subparagraph 2, if we take it 5 lines up from the bottom of the paragraph, perhaps, I'm so sorry, we can go to the beginning of the paragraph. First, what happened in relation to the proceedings. Number one, Mr. Williams was appointed as the authorised representative to resist the proceedings. Then, number two, the application was opposed, and it was opposed, as made clear in the penultimate sentence of the paragraph, at a time when the FFP directors were in post. Now, they lost that application. They were avoided to cause the general partner to disclose the information. And then, importantly, if we could go back to page 35 of the record, back within the judgment of, I'm so sorry, page 20 of the record. Paragraph 35 at page 20. Apologies for misspeaking. So when that information was provided to the plaintiffs, as made clear at paragraph 35, they relied in part on that information to make the particularised allegations which they now make against the general partner, Mr. Williams, Wellspring and KGLI Asia. So in other words, the documents that the GP, acting by the FFP directors, originally refused to hand over were utilised to formulate the claims. The fourth background matter concerns the connections between the general partner and the appellants, and I'm sure the board has those at their fingertips already, but in case it assists, if we could go to page 97 of the record. Back within the Court of Appeal's judgment, paragraph 154 sets out their key findings in relation to the connections. Starting, if we may, at Roman 1 with Mr. Williams, he is the sole beneficial owner of the general partner. One sees that in the first and second sentences of subparagraph 1. Second, as we saw a moment ago, Mr. Williams was the person appointed to defend the Section 22 proceedings. That's Roman 2. Third, back within Roman 1, the last sentence, he was also the investment director of the sponsor and placement agent. That is KGL Kuwait, which is the 8th defendant to the proceedings. So he was the investment director of the 8th defendant, and then he was a member of the investment committee of the fund. Moving next to Wellspring, that's Roman 3 of the Court of Appeal's judgment. And again, very clear connections between Mr. Williams and Wellspring. He's the CEO, CFO, President, Vice President, Treasurer and Secretary of Wellspring. So, key involvement in the management of Wellspring. Number 2, Wellspring is owned by a family trust of which he is a trustee. And number 3, it has been recently confirmed that the beneficiaries of the trust are Mr. Williams, members of Mr. Williams's family. Then finally, connections with D4. Mr. Williams, CEO of D4. How else is D4 involved? It is wholly owned by the 8th defendant, a limited partner in which Mr. Williams was also involved. And as I said a moment ago, it was the sponsor and placement agent of the Port Fund. And indeed, it was the ultimate beneficial owner of the investment manager, and the board will recall that it was the investment manager's entitlement or not to money which was at issue in the DIFC proceedings. Now, it was against the background of the nature of the claims, namely a conspiracy involving the general partner and breaches of trust and duty by the general partner and knowing receipt of property based on those claims, that the Court of Appeal found that the general partner was under an inhibition in relation to taking of proceedings against the appellants. I think maybe now a convenient moment to address, although hopefully in shorter form than I was going to, the refrain we saw throughout the appellant's case that the Court of Appeal found that there was only a potential conflict of interest and that the Court of Appeal did not find that the general partner was under an actual conflict of interest. Now, we say the Court of Appeal made a clear finding of actual conflict and did so rightly. And if we can start, please, at page 98 of the record, paragraph 158. There you will see the Court of Appeal introducing the conflict. We'll come to Henderson in due course, but saying in our judgment there's a similar conflict in the present case. On the plaintiff's case, D1 as the general partner was deeply involved in all the alleged wrongdoing, as was Mr. Williams. D1 has to decide whether to institute proceedings against D2 to D4 in circumstances where. And may I just invite the board to remind themselves of the reasons given by the Court of Appeal. And as the board will see at paragraph 159, there is a punchline in relation to the effect of that, and there is a clear finding of an obvious and serious conflict of interest, which leads to D1 being under an inhibition, which would amount to special circumstances in the context of a trust or limited partnership. And this inhibition also means the failure by D1 to bring proceedings against D2 to D4 is without cause for the purposes of section 33(3). Now, note within that we say, one, a finding of actual conflict, and two, a reference by way of check to the trust and limited partnership principles and not those relating to companies, we say rightly. If we could then please move over the page to paragraph 163. And again, the board looked at this paragraph in detail with Mr. Chapman earlier this morning. We say what the board is very clearly doing there is considering the two submissions made by Mr. Chapman to try and get around the conflict which was found at paragraph 159, namely the appointment of the FFP directors and two, the undertaking, and saying that just doesn't work. And when the court says that just doesn't work, it's very clear from the reasoning within the first 5 lines of the paragraph that it doesn't work because the Court of Appeal is saying one needs to focus on the general partner. That's what the statute tells one to do, not to look at the directors for the time being. And in that context, the general partner is subject to the conflicts of interest we have summarised above, and thus cannot be seen to be in a position to take a fair and independent decision about the potential litigation. So we say a clear finding again there of actual conflict. Now, whether the comment about the liquidator is correct or not may be a matter for another day. I'm very happy to assist the board on that if you would like to hear, but we say primarily the point doesn't go anywhere today because there is no liquidator of the general partner. There is plainly an actual conflict as found by the Court of Appeal. There's been no attempt to appoint a new general partner to try and cleanse that conflict. And I think one point I would make, Mr. Chapman suggested that, well, what the court is saying or what could be done is the wrongdoer here, Mr. Williams, could cure the conflict by simply appointing a new general partner. Now we say that's plainly wrong. One gets oneself just into the position you started. You have exactly the same conflict again. It's only if you have a new general partner being put in who is free of the conflict that you then cleanse the conflict. And then, if I may, if we can look at paragraph 166, which I'm not sure the board was taken to at page 100. Having discussed the B Trust case, which we'll come back to if the board would be assisted in due course, the finding at the very end of 166 is one that I'd like to draw to the board's attention. At beginning, the fact is, 5 lines up from the bottom, where the board say the fact is that the decision as to whether to institute proceedings on behalf of the TPF involved consideration by the GP of whether to sue itself as an alleged co-conspirator and whether to sue its beneficial owner and 2 closely linked companies in circumstances where the claims were said to arise on the basis of the wrongdoing of the GP and its beneficial owner. So very clearly setting the scene for what the conflict is in the present case, an actual conflict. And then at paragraph 167, in the final sentence, which is the key sentence, which I think, again, the board didn't see earlier, what the Court of Appeal says in conclusion is there is no doubt in our view that D1 was and is suffering from an inhibition which leads to the conclusion that, subject to the exercise of any discretion, it is appropriate for the plaintiffs to bring the derivative claims on behalf of TPF pursuant to section 33.3 against D2 to D4. So I apologise, rather lengthy way of getting to the opening submission, which is, we say very clearly when one looks at the reasoning of the Court of Appeal, there is a finding of actual conflict on the part of the general partner. That was our 4th background point on the judgments below. The 5th background point concerns the findings made by Mr. Justice Parker in relation to the FFP directors and what the Court of Appeal said about those findings. Now, as the board knows, we say the position of the FFP directors and the question of whether they as individuals were inhibited is ultimately irrelevant to the disposal of the appeal because the statute requires one to look at the general partner and not the underlying directors from time to time. But of course, the appellants focus their argument solely on the role of the FFP directors. The difficulty, we say, and we'll come back to it in legal submission later, but the difficulty, we say, by reference to what the lower courts have found, is that the argument is in any event futile. And the reason we say that is by reference to the unchallenged findings of Mr. Justice Parker when evaluating the evidence before him. And can I give the court the reference to where that reasoning can be found and then maybe just turn up the punchline this morning. It's in the record at pages 33 to 35. So at page 33, the board will find the heading FFP Directors. And this is where Mr. Justice Parker goes on to consider what the position would be, as he says at paragraph 107, in case he's wrong, that one looks at the general partner and not the underlying directors from time to time. So he doesn't just stop with the general partner. He says, well, I think one only needs to look at the general partner, but in case I'm wrong about that, what about the FFP directors?
You said he applied the wrong standard of proof. Is that right? Prima facie case.
Well, my lord, correct that the Court of Appeal says the standard was wrong, but the Court of Appeal notes he does use the word good arguable case, and more importantly, when we come to the Court of Appeal in a moment, they expressly say that the judge would have been entitled to make the findings of fact in relation to the FFP directors that he did. And it's the finding that I wanted to show the court, the punchline of which is at page 35 of the record, paragraph 121.
Do you equate his use of the phrase, the decisions being insufficiently distinct, to mean that he didn't truly accept their true independence?
My lord, I do, and one gets that. And I'm so sorry. Maybe it would help to see
what he meant by that's not very clear expression on its own, is it?
Well, precisely. Yeah.
May I help with that? Could we go back to page 33? Paragraph 109, second sentence, he introduces it by saying, neither does it change my conclusion below that there is a real conflict that the FFP directors have not themselves identified. And then paragraph 110, he says he finds that there's a prima facie case that they are unable to assess the claims properly in an independent and objective way. And at the end, one will see the punchline in relation to that in the final two sentences. It is, however, the case that they owe their duties primarily to the GP, and it is obviously not in the GP's interest to be sued. That seems to me to place them in a position where they are seriously inhibited from making impartial decisions.
Yes, so any director of the general partner faced with this conflict would have a fiduciary duty to protect the back of the general partner.
My lord, yes.
But that's an institutional point, about irrespective of the particular circumstances. But he seems also to be making a finding about the actual situation of these, in which these people have reached their decision.
My lord, he does. The finding, as I pointed the board to a moment in the first line of paragraph 110, unable to assess properly in an independent and objective way. Paragraph 111, a prima facie case that they've been guided until recently in their investigations by information provided by those who were under investigation themselves and by their legal advisors who were also conflicted. And then paragraph 113, doesn't change the finding there's a prima facie case that they're not capable of being truly independent and objective.
It's the previous paragraph
Yeah.
doesn't make that change. It's the funding question.
My Lord, yes. Paragraph 114, he refers to the fact that the memoranda that have been put together were perhaps of necessity confined to interviewing individuals or representatives of parties who are either defendants or who are closely associated with them. In other words, the people who have benefited from the payments. Paragraph 117, he says, the question of cause cannot be one for the FFP directors to decide alone without more given the circumstances of this case. Paragraph 119, he refers to the court having a role to ensure that the process described by the FFP directors was fair and the decisions were impartial and sound. And he says he's unable to accept the FFP director's views at this stage that the general partner had cause not to institute the claims. And then he says a prima facie case that the decisions were not taken in fair or safe circumstances, and an arguable case that they failed to bring the claims without cause. And then the punchline, the compressed reasoning following from the previous paragraphs that the board has already seen at paragraph 121. I also mentioned the Court of Appeal. We say the Court of Appeal went out of its way to make clear that the judge was entitled to reach the conclusion that he did in relation to the FFP directors. And can I please make that good by turning up page 101 of the record? Now, Mr. Chapman said earlier this morning that the Court of Appeal did not consider the position of the FFP directors. We say they did at 168. They said two things. Number one, because they've upheld the judge on the general partner being the relevant decision maker and the general partner being inhibited, rather than needing to look at the directors from time to time, they don't need to address his finding about the position of the FFP directors. But they go on to say that if they had found it necessary to do so, they would have considered the judge was entitled to reach the conclusions which he did in this respect. Now that clearly can be and only can be a reference to the paragraphs we've just looked at. The sixth background point is the unusual nature of the present appeal. It's not a case of a company seeking to prevent a minority shareholder from pursuing a derivative claim. That much is clear. It's also not a case of the example that Mr. Chapman gave to the board this morning of a minority disgruntled limited partner seeking to advance a spurious claim on behalf of the partnership. Now, in that case, there are two answers to the point raised by Mr. Chapman. Number one, The test, as set out by the Court of Appeal, requires there to be a good arguable claim. In the present case, it's accepted by the appellants that there is one. In Mr. Chapman's example of a spurious claim by a minority limited partner looking to cause trouble, there would be no basis for a derivative claim, because there needs to be a good arguable claim. The conflict alone is clearly not enough. In those circumstances, the general partner could, in the normal way, apply to strike out the claim. Or the defendants could. In addition, in that situation, at the discretionary stage, if the minority limited partner was, as Mr. Chapman suggested, a troublemaker with a spurious claim, the other limited partners can come before the court and say that, apart from anything else, permission should not be granted on a discretionary basis because the claim is not in the best interest of the fund. We hold the majority economic interest. We are not conflicted wrongdoers. We are independent, and we believe permission should not be granted. And so we say that example, although a purely theoretical case, is not a good example in the context of the present appeal. Nor is this an attempt by a general partner to prevent the bringing of the claim. We didn't hear very much about the receivers this morning. They were mentioned within the written case of Mr. Chapman. We assume that he's not pursuing any arguments by reference to the position of the receivers, and we rather assume that because they have made their position clear in a letter written by Collis Krill, their attorneys. And in essence, and I can give the board the reference to the letter, it's page 2202 of the record. So this is written by Collis Krill, who are the attorneys to the receivers appointed by Mr. Justice Parker after the decision of the Court of Appeal. And the genesis of the letter can be seen over the page at 2203 on paragraph 6. They're responding to a letter from Campbell's, the attorneys to the appellants. And paragraph 6 shows that Campbell's, the attorneys to the appellants, were essentially trying to get the receivers to take a position on the record about the derivative claims. So they wanted the receivers to say something about the merits of the derivative claims. Now, the response at paragraph 8, we say, is telling. In particular, could I invite the board, please, to read paragraphs A and B and C, Roman 1. So as the board sees, the receivers recognise the findings by the court of an inhibition, and then at C, make clear that they agree that they can't do the review of the merits that the appellants are asking them to do, because they themselves recognise within C, Roman 1, the conflict involved in that exercise. Now, I drew attention to this because there was a suggestion in the appellant's written case that weight should be given to the fact that the receivers have not disavowed the FFP director's conclusions. There's a very clear explanation from the receivers as to why they don't believe it's appropriate for them to conduct an investigation into the claims. So the unusual nature, we say, of the present case is the general partner is not opposing the bringing of the claims. No limited partners are opposing the bringing of the claims. In fact, over 80% by value want the claims to be brought. It's only defendants who do not believe they can strike out the claims on the merits who are seeking to assert the statutory gateway defence. Now, we agree there's a standing point, but we say that if we are through the gateway of standing, there is a very easy answer on discretion to whether we should be able to bring the claim against that background. The final background point to highlight concerns the status of the direct claims pleaded against Mr. Williams and Wellspring, remembering there are no direct claims against the third appellant, KGLI Asia. Now, this is relevant in view of the finding by the Court of Appeal that one of the reasons why it should exercise its discretion for the claims to be brought was there was sufficient uncertainty as to whether the direct claims would ultimately work at trial. And can I just remind the board of that point at page 101 of the record? It's paragraphs 169 and 170 of the judgment, and if I can just summarise it, what the Court of Appeal said is, well, the defendants are saying that there's an alternative remedy of the direct claims that should be a reason for refusing the derivative claims. We disagree. We disagree because the appellants here today have made clear that they wish to argue that the direct claims cannot be brought as a matter of standing, and there is some doubt as to whether at trial the direct claims could involve an order for restoration of the fund. In other words, whether the direct claims by only 80% by value of the limited partners could get all of the money as a result of the breaches of duty back into the fund. And what the Court of Appeal said the derivative claims are important to guard against is a situation at which the court finds there is no ability in relation to direct claims to order restoration of the fund. That won't matter because the derivative claims clearly will allow you to get that relief, recovering the entirety of the loss. Now, the point we make there is, in their written case, although fairly to Mr. Chapman, not in his oral submissions this morning, the appellant sought to challenge that conclusion and sought to rely again on the direct claims as a reason for challenging the Court of Appeal's exercise of its discretion. Now, we say they can't do so for two reasons. One, they asked for permission to do so. That was ground two of their grounds. Page 227 for the board's note. Permission was refused to bring that ground of challenge. Now we say, given the refusal of that permission, what the appellants clearly can't do by way of the back door is to try and bring those points in again in the discretionary context. Subject to the board, I note the time. That concludes the 7 points on the background, if that's a convenient moment.
Yes, certainly. We'll adjourn now and resume at 2 o'clock.
Thank you.